Yes, show the light. So. Yes.
One witness present here.
Yes, who's the counsel for the accused?
Your Honor, the accused is present.
Huh?
However, the conducting counsel is having matter at the Meghalaya High Court. So he informed me to bring before this honorable court to receive the cross-examination.
Can we do so?
That's all right.
Huh?
That's all the information which I got from the.
We will not adjourn the matter on that ground. Next. A person busy in some other court is not the ground for adjourning the matter. Why this court is not important? A person who is busy in some other court is not a ground for adjournment. Please read section 209. CRPC, please read section 209. The court, the law does not permit us to adjourn the matter on the ground that the counsel is busy in some other court. Please read section 209 of CRPC. And the corresponding section of 209 in BNSS, what will be there? Please check it. Please check it. Don't make any submissions contrary to law. Yes, next. We are not adjourning the matter. You want to cross. You don't want to cross, we'll close it. And where is an application for adjournment? File an application. We'll pass an appropriate order. Please see now. If you are asking an adjournment, you should know in a trial what is the law, under which provision of law you can pray for an adjournment, on what grounds you can pray for an adjournment. See, have a look on 209 and then you speak. Yes, we are not adjourning this matter. Yes, next please.
Thomas John,
For evidence, but there is no report
Huh?
in respect of the witness.
Dimondhar,
His present.
Thomas John Niklam, Pinbet Talang.
I filed a bail today for Thomas Jr.
Where's the bail application? Who is appearing for the prosecution?
Yes, I am appearing here.
We granted bail to Dimondhar.
Yes, right.
When?
Order dated 27/4/2026.
What was the ground for granting bail?
No witness was examined for. No witness was examined for a long period. For a long period of time.
Today also no witness.
No, Your Honor.
Yes. There
As
is no
of-
report, Your Honor.
As of now, it has been 10 months, 14 days, Your Honor, without witnesses.
Yes, what do you have to say on the bail application? Have you served the copy to the prosecution?
Yes, I got.
Where's the order passed? Where is the order granting bail to Dimondhar? Yes, please tell me.
Your Honor, in this case, there is intimidation from this accused against those witnesses. If released on bail, there is likelihood that the witness.
Okay, we agree with you. How long will keep him? How long will keep him? How long? You're right, absolutely right. But how long will detain him? This is not a preventive detention.
Yes.
How long will detain him? Under preventive detention, we can detain a person without any trial, without there being any case, for the purpose of maintaining law and order, or for the purpose of maintaining public order. But this is not a preventive detention. You say that he has influenced the witnesses or he's intimidating the witnesses. Well, that's good. That's why we had taken custody of the accused persons. But for 1 year, you have not produced witnesses, and now you are raising objection to the grant of bail. Yes, your objection is valid. If you can satisfy me that how long we are going to keep the accused in jail without trial. Yes.
With 3 more witnesses. In that case, your condition may be passed because there are only 3 more witnesses in this case.
But you are not bringing the witnesses for past 10 months and 14 days.
Someone did not return with a
Whatever
report.
may be, the fact remains that the trial is not proceeding. And they have been detained for the purpose of trial. Bail application 15 is a bail application for the release
Yes,
of
sir.
the accused. Yes. Anything else you have to say?
Last date, received report that one witness expired. So today there is no witness.
So whatever may be the case, but the trial is not proceeding, isn't it?
In this case, actually it's fixed after duration of every fortnight,
Yes.
So some report becomes very difficult to return on time. On that basis also, we find it difficult. If you, can refix the matter one month for production and a fortnight, and after that, you can take steps for evidence, Because in short duration of time, it's very impossible. Time is very crumbling on us, to issue summons. By the time it is again refixed, very unlikely what summons will return.
Law says that the matter should go on day-to-day trial.
I understand, yes.
But what is so difficult? What's so difficult for you to produce the witnesses? Why do you look at the remand of the accused for 14 days? If you have the intention and desire to produce the witnesses during the course of trial, you can always issue someone.
Sorry.
What is the difficulty? What is it? Is it so difficult to issue someone to the witnesses? If you have 3 witnesses,
These are witnesses, from Assam and Changsari.
let it be any place. If your grievances is this, that the 14 days time is not a sufficient time to produce the witnesses, what stops you from filing for taking steps for all the 3 witnesses on 3 different dates? You can take steps for all the 3 witnesses now. One witness to appear on the next production date, another witness to appear on the next production date, and the third witness to appear.
True.
That you can do it, and that solves your problem with regard to the time of 14 days.
Problem is that this thing which is out of state, it takes some time.
So that you can do it. What stops you?
Else from that we have only IO left.
You know the matter will come up after every 14 days.
Yes.
Meaning thereby, you know the dates. Now, if you know the dates, you can issue summon to the witnesses. For if the witness is out of station and he has to come, you require 1 month time. Then you issue summon to the witness to appear for this court on the next production date. That solves the problem.
True.
But if we take into consideration your argument that 14 days is not sufficient time, then we cannot proceed with the trial.
I'm seeking honest indulgence because these are witnesses which belong to other states. Had it been in this state, yes, we could.
All right, there is no issue about that. You are finding difficulty in securing the presence of the witnesses. All right. Now, I can understand that you found it difficult to produce the witnesses for a month, or for that matter, 2 months.
Prior to that,
10 months.
Yes, prior to that, we took steps.
No,
Yes.
we are not concerned with that. You might have taken steps. You might have taken steps. You have attempted to serve. All bona fide effort has been made
Yes.
to secure the presence. But that is what you have done. But look at the other side. The accused is in jail. For what purpose?
Yes, there was a threat on.
No, whatever, maybe there was a threat, but ultimately these threats and everything needs to have some bearing on the trial, isn't it? So they are in custody for the purpose of trial, and to see that the witnesses are not suborned. But the trial is not proceeding. You may have all good reasons. You may have all good reasons for not producing the witnesses, but the fact remains that the trial is not proceeding, and they are being remanded in custody from time to time. For 10 months, we have remanded him in custody without trial. What is the justification?
Yes, but apart from these two witnesses, only I left.
Summon him, but then we are not. How can we say that when his trial was, one of the accused person's trial was delayed and we granted bail, and this person also similarly situated? How can we deny bail to him?
We are not against the bail,
Yes.
but strict condition be imposed. But the fact remains that these are the witnesses. Why we are not able to produce them? Because we are from outside the state.
Okay, we understand, but then 10 months time is a good time. It's a good time for the prosecution to produce witnesses. And if you have failed, of course, then this benefit should go to the accused. Okay. Well, passing the earlier order, we have already relied on the decision of the Supreme Court placed by the council, where it says that having regard to the aforesaid, we wonder what period of time the trial will ultimately conclude. However serious a crime may be, an accused has the right to speedy trial as enshrined under the Constitution of India. Over a period of time, the trial courts and the high courts have forgotten a very well settled principle of law that the bail is not to be withheld as a punishment. So detaining him is for the purpose of trial, not a preventive detention or in any sort of a punishment. We are not punishing him for the purpose of threatening the witness. That was just an allegation. We are not prosecuting him and detaining him.
We are also not against his bail, but just to bring to the notice of this honorable court, why it's not that we have not taken steps, but the only fact remains that these are witnesses which are from Assam.
This is a bail application. This is a bail application for the release of the accused Thomas Jones Rinklem, filed under section 483 of BNSS. The application is supported by an affidavit and moved by learned counsel T. Lambang. Yes. Heard learned counsel for the petitioner. Heard learned counsel for the accused. Heard learned prosecutor S. Chansan. Learned counsel for the accused submits that the accused has been in custody for 346 days. Bracket even 11 months, 12 days. And he's facing trial on a charge under section 302/392.
302/392/34.
302/392/34
IPC.
34 IPC. Full stop. The prosecution has examined 15 witnesses. 17 witnesses. The last witness was examined on
7/7/25.
7/7/2025. Full stop. The prosecution has failed to produce witnesses for the last 10 months
14 days.
and 14 days. 10 months and 14 days. Full stop. The defense counsel further submits that the detention of the accused is for the purpose of trial and the trial is not proceeding as the prosecution has failed to produce witnesses. As such, praise for grant of bail. Full stop. The defense counsel has also brought to the notice of this court that the co-accused Dimondhar was granted bail, has been granted bail by order dated 27/4/2026, passed in bail application number 8 of 2026 on the ground of delay in trial. The defense prays for parity as the accused Thomas John Rinklem is also similarly situated. The prosecutor submits that the witnesses could not be produced before this court as they reside outside the state of Meghalaya. Several attempts were made to secure the presence of the witnesses. However, the prosecution did not succeed. Further, the prosecution submits that there is no latches. There is no latches on part of the prosecution in expediting the trial. Stop. Further, the trial. Don't have full stop. The prosecution has also brought to the notice of this court that there are some materials on record discloses that the accused person has indulged in influencing the witnesses which has resulted in detention of the accused in custody. If the accused is enlarged on bail, he may influence the witnesses. The prosecution. First of all, that upon hearing the rival upon hearing the contending counsel, this court finds that this court finds it very strange that the prosecution is praying for. The prosecution is canvassing that the detention of the accused is required for the protection of the witnesses, and the prosecution does not know where are the witnesses. This is evident from the fact that prosecution has failed to produce witnesses for past 10 months, 14 days on the ground that they could not be traced. And they reside outside the state of Meghalaya. The contention of the prosecution on the face of it appears to be absurd. Full stop. Next one. This court finds the co-accused, Dimon Dhar, is similarly situated with the accused Thomas John Rincklem. This court had granted bail to the co-accused after elaborately dealing with the right of the accused to speedy trial. First off, that on the principle of parity, the accused Thomas John is granted bail. Same condition. Bail application stands allowed and disposed of. How can you pay protections for the witness? And you don't know the witness, where is it? Where is he? He or she.
In fact, this is the first date that we should summon to the Assam witnesses.
They're too far. That the objection sounds academic. Yes.
Like this year,
You know,
if
conditions, huh?
Same condition.
I pray for if matter for evidence maybe for 1 month, and for production after every 14 days,
We cancel a bill.
Yes,
We'll cancel a bill. We granted bail because you say that there is a delay in trial.
Yes,
When we are expediting the trial, you want it to be delayed.
sir.
Strange. You want it to be delayed? I cancel your bail. Take custody of your accused. We granted you bail because there is a delay in trial.
Yes, sir.
Now you're making a prayer that the trial should be delayed, should be prolonged, long dates should be fixed. You can't blow hot and cold. You've enjoyed the benefit of the trial being delayed. We granted bail to you because the trial is delayed. Now after bail being granted, you say that the case should be fixed in a long date. Now once you are on bail, then you yourself want to delay the trial.
No.
And then if you want to fix up after a month, we will fix it up. In that case, we'll cancel your bail. Yes. Don't make that prayer. Yes. Don't make that prayer. Wait 1 second. We'll pass the order on the main case. Accused Dimon Dhar, present. Accused Thomas John Rincklem, produced from jail Azhar. He has been granted bail by order dated
27.
What 27? Today is 27.
No, it is 21st. I thought for the accused, Demandar,
Don't think. See, today is 27.
21st. first
Accused
fact.
Thomas John Renklam has been granted bail by order dated 21/05/2026, passed in bail application number
15,
15.
26.
However, he has failed to furnish bailers. However, he has failed to furnish sureties. As such, he is remanded back to 14 days judicial custody. Penbaj Talang produced from jail Azad through VC. Remanded back. No report on the summon issued to the witness. Prosecution shall expedite the trial by securing the presence of the witnesses. Refix for evidence. Che. Yes.
Hamon Timon.
Yes.
What witness, Your Honor?
Who is the witness and for what purpose? Eyewitness. Where is the witness? What case is this? What is the charge?
326 and 302.
Berkir Khan. Peter So.
Yes.
No, this case, no witness.
Yes. Who?
Yes. Accused was present, yeah.
What case is this?
326, Your Honor. 326.
No.
326 is triable by the session court.
307.
Young lawyer, you don't appear with file in the court. Offense under section 326 is tried by the session court. You don't know this case.
Yes. Yes, Your Honor.
This happened in the football ground.
Yes, Your Honor.
The boy was taken.
Yes, Your Honor.
You don't know your own case.
367, 326, and 34, Your Honor.
See, you should know the charge. How come? These are fundamental things when you appear in the
My
court.
apologies.
Don't you think the court is not going to ask you that what is the case all about? This case, how many witnesses have been examined? One. Okay, this is a 224 case. All right. Please expedite the matter. They are on bail, na?
Yes, yes, Your Honor.
Accused Miriki Dakhar and Peter Su present along with defense counsel Shri Eldhar. What happened to the BF issued summon? No report on the summon. No report on the summon issued to the witness. Prosecution is at liberty to take fresh step. Refix for evidence. Yes.
Accused Mr. Khan.
Yes. Yes.
One hay cut the thumb.
Yes. 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 What is the charge, madam?
302.
All right.
302, 326, and 327.
Okay. What has happened? There's no witness. Accused one He Prakhat Lathong, produced from Jail Azad. Chief Legal Aid Defense Counsel, Srimati Sonso present. Prosecutor, Additional Prosecutor S. Chansang present. Prosecution shall ensure that witness is present on the next date fixed.
Yes.
Prosecution to take steps to summon the witnesses. Yes. Yes.
Romi Chalam.
Yes.
We have issued one witness, Nikki Shila, you know. Is received by, seems relative, you know, but he's not here today.
All right.
Accused is present.
All right. Accused Romi Chalam present. What is this case, madam?
302.
Accused Romi
Assault on the wife.
Huh?
Assault on the wife.
died.
Died.
Accused Romi Chalam, he's on bail.
Yes, sir.
Romi Chalam present along with defense counsel, Srimati So and so, Chief Legal Aid Defense Counsel. Prosecutor Shri L.S. Yambon present. Summon issued to the witness returned duly served. However, the witness is absent without any steps. Prosecution is at liberty to take fresh step. Yes. Yes. Plan Dakar, Shihun Dakar, Jimon Dakar, all these matters will take up. Will pass the judgment. Who is appearing in this Jimon Dakar? Yes. What do you want? Don't ask time.
Honor, this fixed final argument, so I'm not ready, Honor.
We are ready.
Some more time.
We are ready. Okay. We are ready.
No,
Be here. Be here. Be here.
And I am not the counsel for this.
All right. We'll make you the counsel.
Counsel for this Jiman Karsis.
We will make you the counsel. If you are not the counsel, we'll make you the counsel. Read the file. You have the file? Do you have the file?
Yes, sir.
Read the file. Yes.
I want.
Just me.
From the prosecution evidence discussed above, the prosecution has established that the accused and the deceased were present in the house of PW1 on 9/10/2016 and there was a quarrel between them. The accused, in the fit of anger, took a wooden handle of an axe and hit his brother, causing his death. This fact has been established through the evidence of PW1. Her testimony gets further fortified by the evidence of PW2. The cross-examination of PW1 and PW2 has been only on the question of deceased being a trouble creator in the house. Body of the deceased was found in the house of PW1 in a pool of blood. The post-mortem report Exhibit 3 and the inquest report Exhibit 7 explains the nature of the injuries found on the body. The evidence of PW5 doctor reveals the cause of death was the injury found on the body. Prosecution has established that the accused had unleashed fatal blow with a wooden axe handle to his brother, Kunmo Bet Ashraf, and he succumbed to the injuries. The accused is in no denial of his act in his explanation under section 313 of CRPC. Prosecution has established that the accused caused the death of his brother on 9/10/2016 at around 8 p.m. by hitting him with a wooden handle axe. That upon analyzing the proposition of law discussed above, this court finds that there is a fine distinction between murder and culpable homicide not amounting to murder. Once a case falls in a category of a culpable homicide not amounting to murder, the court will have to determine if the case falls in the first part or in second part of section 304 IPC. From the evidence which has unfolded during the course of trial, prosecution has established that the accused had caused death of his brother on 9/10/2016 by hitting him with a wooden handle of an axe on his head. The death of the brother of the accused was a homicide. However, the prosecution evidence does not establish that the accused had inflicted injury to his brother with an intention and knowledge that the injury was sufficient in ordinary course of nature to cause death, or with the knowledge that the injury was so imminently dangerous that it must in all probability cause death. The act of the accused does not fall under section 300 IPC. As such, culpable homicide committed by the accused does not amount to murder. Present case does not fall under section 300 of IPC. It is not the exception of section 300 IPC which renders the act of the accused culpable homicide not amounting to murder. As such, the act of the accused would not constitute an offence under part 1 of section 304 IPC. Prosecution evidence establishes that the accused and prosecution evidence establishes that the deceased and the accused were brother and they were living together in the same house along with PW1, mother. The evidence of PW1 and PW2 establishes that the deceased constantly caused trouble in the house and threatened the family members. On the day of the incident, the deceased came to the house and threatened his sibling. He went to the room of the accused and assaulted him. In other words, the deceased was the aggressor. The evidence of PW1 reveals that the accused, in the fit of his anger, took a wooden handle of axe and hit the deceased, resulting in his death. The accused did not have the intention to cause death of his brother. However, he knew that striking somebody on his head with a wooden handle of an axe would likely cause death. As discussed above, the act of the accused falls in the category of a culpable homicide not amounting to murder under Part 2 of Section 304 IPC. That for the reason discussed above in the foregoing paragraph on the points which arose for determination, this court finds that the prosecution has established beyond reasonable doubt that the accused has committed an offence of culpable homicide not amounting to murder, punishable under Section Part 2 of Section 304 IPC. The accused, Hawan Shamprang Shadap, is found guilty for an offence of culpable homicide not amounting to murder and convicted under Part 2 of Section 304 IPC. The accused who is present before the court is taken into custody. Bail bond of the accused stands revoked. Here. Yes, please inform him he's been found guilty for killing his brother.
Hồiวันนี้ได้รายกฎต่อดิฉันก็ว่าดัดมีโอนึกไปอยู่มีต่างเดิมเอ็มจิหมดต่างเดิมติดมีในว่าดัดมีโอแต่มาแต่ขนาดหนองคนเดียวมาแต่ปังงัดก็ไม่กันดอนเลียนนอดโซ่ยองบรรดาบัวอามา
He has anything to say?
เอ็มโอออกไหม
The accused Hoi Wan Champrang Sadap, present along with defense counsel so and so, prosecutor so and so present. Judgment delivered in open court in presence of the rival counsel and the accused in a separate sheet running in 26 pages. The accused is found guilty for an offence of culpable homicide not amounting to murder and convicted under Part 2 of Section 304 IPC. Copy of the judgment shall be supplied. The accused who is present before the court is taken into custody. Bail bond of the accused stands revoked. Copy of the judgment shall be supplied free of cost to the accused. Fixed for hearing on sentence. You want to hear on sentence?
Yes.
You want to hear on sentence?
Second half.
What do you want to hear on sentence? Yes, how much sentence do you want?
Here, 304 Part 2 provide up to 10 years, which may extend to 10 years or with fine.
You, without going through the judgment, you want sentence to hear on sentence?
No, not now. After reading the judgment.
Tomorrow can be done.
Huh?
Tomorrow. No hurry.
Yes, it's up to you. If you want, we can hear.
No,
Tomorrow,
no hurry.
tomorrow.
Please for hearing on sentence tomorrow. The accused shall be produced before this court tomorrow for hearing on sentence. Yes, next.
Banki Suna.
See,
The convict will be taken in. Yes.
He's come with whom?
Mother.
Where is the mother? 1 second. Explain her.
New computer rem ko dum the rem ko o tam to the ya yo cha thang cha ji te ni dang rai ren na ma the mình to the chim yo the ya yo cha ji man ko tam da ha hy te ha bu ka da wi sai lan sai te chdi na atte dang rai ren na
His son is married.
yes sir
How many children?
2 minor children
Staying with whom?
to stay with his wife.
Wife has come.
No.
She understands that why her son has been sent to jail.
He's now told P. will let about Ponong P. I go to jail by Remy only. Now told her.
Explain her that he's been sent to jail because he's been found guilty for killing his brother.
Need a pack. Oh, but with a champion to I want order that ought to be you said the native that to by you to come by. But they down there. No,
She wants to say anything?
crap you on. Yeah. Crap you on her coat at that. Aha, you get to why. He tell the I ram you why one crap you club. No, sir, she doesn't want to speak.
You file an affidavit. You give the details tomorrow, so
Yes.
that we'll be in a better position to pass the sentence.
Okay. Oh, madam.
Yes, tell.
Kate em poche te ventare te slim te muslim ni
What is she saying?
No, so she said how long he'll be in jail. So I said I told her
Tomorrow we'll
yes
decide.
tomorrow. Means te urai ko te. Ma. Tao em gajing say hello te gat once nem sa. Ma. Months to the pan to eh? Months to the man to pan. Means step.
Yes. Yes.
Offer me what charge?
It's only 307?
Yes.
Very.
Yeah, ini mana? Jangan ini. No.
That you on 27/4/2024 at around 3:30 a.m. Brutally assaulted Rajesh Sari at Rajasthan Dhaba, Tirsi Jawai bypass with an intention to cause his death. Full stop. You have committed an offence of attempt to murder, which is punishable under section 307 IPC. Yes. Yes. Yes.
Kaniga court ang mewa aga arbonya trik mana uso ara jara porsu hay por lewaji listing step that the bomb that taught me you rajas sari apo kaniga rajasthan thaba daga jing tmu yo penyap yo le na bem le mi idain
Charge free under section so that's not guilty. Prosecution to take steps to summon the witnesses. Fix for evidence. Yes.
Itu melim nak.
Yes, I was informed by messenger that she will be coming from Korea, so we will take up the case.
Yes. Yes. This POXO appeal will take it up next week. No? Not today. Today we are passing some more judgments. Next week this POXO case.
Presence is also not required.
Next week we'll take. Item number 1 special POXO next week. No? Record the presence of both the counsel. Yes. Yes.
In the meantime, I'll just go down and come back.
LAC man parang dok.
and on palamai affidavit today
What?
for the IO
This matter has proceeded ex-parte.
yes all opposite party even the insurance
So this is all. Are you bringing some more evidence?
no.
All the deposition has been filed.
Yes, already filed.
We can post it for ex-parte hearing.
What is that?
We can post this matter for ex-parte hearing.
Okay.
The claimant's deposition, the deposition of the claimant's witnesses have been filed. Has been filed.
Yes. This is the last one. Sir.
All right. How many deposition you filed?
Oh, yeah.
Then a counsel for the claimant PD present is filed the deposition of PW or CW4
Yes.
on affidavit which is taken on record. Full stop. Learned counsel submits that this matter has proceeded ex-parte against the OPs,
All three of them. OP1, 2, 3.
against all the OPs
Dated 11/12.
by order dated
11/12/2023.
2023. Full stop. Claimant has filed the deposition of all the CWs,
1, 2, 3, and 4.
bracket CW1, CW2, CW3, CW4. Full stop. Counsel for the claimant prays that CWs may be closed and the matter may be fixed for ex-parte hearing. Full stop. As prayed by the counsel for the claimant, fix this matter for ex-parte hearing. The counsel is at liberty to file written argument. Yes. Huh? Yes. Yes. Where is the witness?
filed this report regarding that I have.
Where's the medical report to substantiate anything to show? Prosecutor. Has informed the court by letter dated 21st May 2026 that the IO of the instant case is suffering from some medical complication for past 1 year. She is on she goes for earned leave off and on. Now she's on earned leave and bedridden. For the above reason, the IO could not appear before this court for almost 1 year. The IO shall appear before this court as and when she is medically fit. Fix her evidence.
One more thing. Yesterday, I filed one application, Senkel case to support the witness. Because now we found out the address of the complainant. Therefore, I make a petition application there.
File is there? Why do you require an application to be filed for summoning the witness? You can summon, no? Or have you closed the witness?
No.
So actually, in this case, this court on the last since the month of March 2025, this court has passed an order that since the witness did not appear on the date fixed and being police officer, so this court directed the prosecutor to file an application if they want to proceed with this instant case. That is the reason we are filing application to proceed with this case.
Prosecution has filed a petition number 45/26 dated 2025/2026. Stating that prosecution has been able to trace the complainant stroke witness as such praised that prosecution may be allowed to proceed with the case by summoning the witness.
Yes, sir.
To stop, pray aloud. Issue summon to Felicita Walang. And summon to the accused persons.
Yes, sir.
The defense counsel shall also be notified of the next date fixed through SMS. Through SMS stroke WhatsApp message. Yes. RPS. Equalizing. Ya, इसका बोलिए
So this incident occurred in the month of 5,2010, 22/5/2010, at a place called Wa'amtu River.
when
On the 22nd 5/2010, at a place called Wa'amtu River.
22nd 5
At around 4:30 p.m.
yes
And the FIR was lodged by PW1 on the same date.
yes
And the case was registered white YPS case number 83 in bracket 5/2010.
under which section
307/34 IPC. On completion of the investigation, a charge sheet was filed, white CS number 8110. 3/9/2010. Under section 324/34 IPC. The trial proceeded and charge was framed on the 26th October 2018. Under section 307/34 IPC. Then the trial proceeded with the evidence of the complainant. I will just read the FIR. Katkum kata subject balik kada weneng ngapentip ya piba driver jonga, that is PW4 Mio susni the victim.
One minute. Yes, tell me
Kat kung subject pada kedua neng ngapen tip ye pi
No, one thing I want to be very clear. FIR was registered under section 307.
307. Charge sheet 324.
Charge sheet was filed under section 324.
Charge frame 307.
Why?
I have no knowledge. That's because it was done by the previous prosecutor. And at the time of framing of charges, so there is
No. Please listen to me. See what might have happened if the case concluded in a charge sheet under section 324.
Yes.
In all probability, not in all probability, with certainty, the charge sheet might have been laid before the committal court. There was no question of the case being committed.
Yes.
Who altered the charge? Can the magistrate alter the charge before whom a charge sheet has been filed? If it was a case like FIR was registered under section 3, FIR was registered under section 307. Police investigates and files a charge sheet under section 324. Now it is for the court either to accept the charge sheet under 324 or ask the police to further investigate and refuse the charge sheet under section 324, but say that prima facie case is made out under section 307 and commit the case for trial.
There is no such others with
The finished case.
no such other from the record that the charge has been
The case
altered
over.
as per the statement of the witnesses on record.
Then the case over. Let's see how it was committed.
That
Show me the charge sheet.
during the cross-examination of the I also he admits.
One second, just 1 minute. Yes.
And so in the cross-examination of the IO also, he agrees that he was advised to change the section from 307 to 304 IPC.
By whom?
He has not mentioned, and the OC.
Hmm.
In his cross-examination, I'll just read that portion only. It is a fact that after consulting with the CI and the OC, I was advised to change the section charge
Is
against
PW?
He is PW3. I was advised to change the section charge against the accused person from 307 IPC to section 324/34 IPC, as the injury is simple in nature.
Yes. Yes.
Yes, I read the FIR. Penting ipi ba driver jonga umeyo susi ulasha penmansau da umokeu aki arut kibreu bekerteng plan dekar bat sion dekar kiba neklik terci ha kapor sau steng janmit kat padang yetong dot li na penthor leng bentedu bat be thong ban pom da kawai klem tip ya kadau ni yo ikren lor kanini nga karpat yiphi ya kaburom spun chong fi ba pinsiu ba ban ken bat pun stom ye gine ki puna kat kom ki kandam chong ka ai this the and I'll go to the evidence of PW1 who is the complainant in this case.
The victim is the driver.
The driver PW4. So, we'll go to the driver.
See, PW1, PW2, PW3,
PW4.
nobody saw.
No, because at the time of the incident, when this accused person assaulted the PW4, the victim, then after that, this PW2, he heard the scream and cry of PW4, and then they went to the spot. And on reaching
Read
the spot,
PW4.
the incident took place on 22/5/2010 at Wamantru River while I was fishing. Two male persons, namely Sishon Dakar and Plan Dakar, came from behind my back and assaulted me on the left side of my back with a spade. I ran from the PO and both the accused person followed me from behind. And I saw Plan Dakar carrying a dao in his hand. Thereafter, two persons passing through the PO by the name Moses, he is PW2, and the other person whose name I do not know saw me and came to my rescue, and both the accused person fled away from the PO. Later, I was shifted to Civil Hospital Juai for medical treatment. My statement was recorded by the police. I can identify both the accused person. Then in his cross-examination, he stated that it is a fact that prior to the incident, I do not know both the accused person. As soon as I was assaulted, I do not know who committed the offense. But when I turned back, I noticed that it was the accused person, but I do not know who had hit me from amongst the two. I was not hospitalized but was discharged after receiving treatment. I was hit only once from the left side of my back. I came to learn about the name of the accused person from the person who came to rescue me. And PW2, after seeing the victim, then he, along with other person, they took the victim to the hospital. And PW1, he stated that She went for washing clothes, and after some time, this PW4, he came running to her with an injury on his back, and he was bleeding. And then he was taken to the house of his relative and later shifted to the hospital. And then PW5 is the doctor who examined the victim on the same date.
Wait, 1 minute. Can you read PW2's evidence?
PW2,
Yes.
Moses.
Yes.
On the day of the incident, I went out for fishing at Mantadu River along with Friday Hing. And while I was about to leave, I washed my hands in the river, and at that time I saw the victim crying and shouting for help. And I saw that the victim was assaulted from his back side, as there were injury marks on his body. I came to learn about two persons, namely Plundakar and Sishondakar, from one cultivator who were chasing the victim. Thereafter, I, along with my friend Friday Hing, took the victim to Civil Hospital Joy for medical treatment. On the same day of the incident, I, along with Friday Hing and PW1, went to lodge the FIR at Jaipur. Yes.
Who's Friday Hing?
He was not examined as witness.
Who's the wife of Friday?
PW1, the complainant, the wife of this Friday. Wife of Friday Hill.
Yes.
And PW5 is the doctor who examined the victim in paragraph 5. He stated his finding on the injury. There was a half-cut injury on his lower back, left side, and it appears to be cut by a sharp weapon. The age of the injury is within 6 hours. The nature of injury is simple injury. Besides this injury, the patient was found to be physically and mentally sound. And in his cross-examination, paragraph number 3, he stated that I agree to the suggestion that simple injury are not life-threatening. And the IO during the investigation, he searched for the weapon but could not locate the weapon, could not be traced out.
Yes.
And he visited the house of both accused persons. The rest of the accused persons were never present in their house, and then they met the IO, he met the local man and requested him to tell him the whereabouts of the both accused persons and ask him to surrender before the police. And in his cross-examination, the one I stated earlier said that
Yes.
in his cross-examination that he was advised to change the section.
Yes. Yes.
And from the evidence on record and as per the testimony of PW4, the victim, because he stated here that he was hit only once from the left side of his back, and he was not hospitalized, and he was discharged on the same day after receiving treatment. And from the evidence of the doctor PW5, that the nature of the injury is simple it's a simple injury and it's not a life-threatening. and from the evidence of the IO in his cross-examination. So, Your Honor, I pray for conviction of the accused under Section 324/34 IPC.
That's all?
Yes.
Yes.
Yes, sir. Please, sir.
Hmm.
I'll come back.
Can we just come? I'll just come back. Just give me 2 minutes. Yes.
Start.
Yes.
I'll go directly to the victim. Now, on plain reading of the statement of the victim and cross-examination, it stated that prior to the incident, he never knew the accused person. And moreover, stated that, I'll just read, it is a fact prior to incident, I do not know the accused person, and moreover, in the later part also, I came to learn about the name of the accused person
From
the
PW2.
person, yes,
He came to know the name of the accused person from PW2.
Yes, from the person who rescued. He did not state exactly who, but from the person.
PW2.
Yes. So what my contention is that, first, PW4, the victim and the accused never met, nor they know each other prior to incident. They only met on that particular day. PW4, who is the victim, never stated the reason which led to the incident. Why would an unknown person came and hit him? He never explained the reason. He stated PW4. PW4, the victim. Prior to the incident, they never met. They don't know. They met that day only while hitting. My argument is that he never stated before this honorable court why he was hit.
Is he supposed to?
Well, I'm coming to that.
Yes.
He stated that he was fishing. In the normal state, he was stand fishing and somebody hit him from the back. Someone hit him from the back, and he stated it was a spade. In my contention was honor, he never stated why he was hit, because why would a normal person, just came and hit a person? They are not mad. They are not mad person. Just roam around, hit some person.
Yes, I can understand what you are submitting.
Yes.
You have explained the evidence of PW4 in a statement under 313.
Yes.
I got your point.
Yes.
But does it that explanation grants you some kind of a exception that you can do so and it is not an offense? Your act is not an offense.
Yes, sir.
If you have forbidden somebody to fish in your pond.
Yes.
And
I never stated I hit in my 313.
You may say that you have not hit.
I said I chased him away.
Right?
I chased him away, both accused. He came on my pond and stepped on the crops.
I told you yesterday also. The statement of the accused under 313 is for the purpose of understanding the evidence.
Yes.
All right?
Yes.
But if you want to establish something, then you have to produce some evidence, isn't it?
Yes.
So what stopped you from coming to the court and accused to come to the court as a witness? Had you said so as a witness, as a DW, and after giving the prosecution to impeach it, and then you say that look, that evidence is there.
So moreover, he stated that while he was fishing, two male person, namely so and so, came from his behind and assaulted him on the left side of his back with a spade, and he ran Then the accused followed him from behind and saw the car carrying a down in his hand. He stated, he was hit with a spade. However, he stated when he ran, he looked back, he saw a dog. That contradicts himself. How would a person stated he was hit by a spade and saw a dog? Moreover, he stated he never know the accused person. He know on the accused person from the PW2. Moreover, how do he know who is Salan, who is Blandakar? Because it's clearly stated that it was.
He says that
it was Blandakar who hold it down. TIP was never conducted to identify.
He says, I don't know who hit me.
No.
He says.
I know about that.
I don't know who had hit me.
It's not about that. No. It's that this portion, I ran from the PO, both the accused person followed. I saw Blandakar carry a dog in his hand.
Yes.
My contention was never know who is Sihan. TIP was not confirmed to tell him that this is Plan, this is. He know only two names and two persons. How he know that the person who held the dog is Blandakar?
Did you ask him?
Oh, yeah.
In cross-examination?
In his cross-examination, he don't know who hit him.
Huh?
He just simply stated he don't know who is the person who hit him.
Read the whole thing. He did
Because-
not know who was the person who struck him
Yes, yes.
among the two persons.
Not a 2%.
He does not. He did not say that I don't know who hit me.
Yes, sir.
He says that among the two,
Yes, sir.
not among the two. The appropriate word would have been between the two.
Between the two.
Between the two
Moreover,
persons, who had struck him, he does not know because he was struck
yes,
from
sir.
behind.
Yes. Moreover, it goes like this. Moreover, he stated he was fishing. He might be in the natural portion fishing. He was hit. Stated he was hit by a spade. And if we see a spade using here, it's a heavy object, If we go to medical record, medical evidence, there's half-inch cut lower back, So imagine, he was fishing natural position, whether he's standing or that was not clear, but he was hit from the back. Suddenly he was hit. Imagine, hitting with a spade. This is not a case that they are fighting and accused try to hit him, he dodged and some scratch mark. This is a case where he was standing fishing in that natural position and someone hit him in the back with a spade. Imagine, the injury should be caused. Or in this case, the doctor who examined the victim said it was half-inch cut lower back, The claim by the victim he was hit by a spade does not corroborate, because if he were to be hit with a spade, there might be a huge injury, However, the doctor said it was half-inch injury. Whether he dodged or I don't think he
Can
was
we,
just in the backside,
While appreciating the evidence, is it humanly possible to get into those kind of a argument that with what force he had hit him? This is physics. All right. What amount of force was applied by the accused while hitting the deceased? Can we examine? Can we go from the point of view of the accused? What amount of force he had applied to understand that what is the amount of force he had applied to hit the accused? How do we make the assessment?
my case was charged under 367.
No, that we'll see later on. How do we make an assessment that what amount of force was used by the accused to hit the deceased? It is only when the accused is actually hit, all right, and there's a contact between the accused and the deceased. If he's using a weapon, the point of contact will determine the amount of force used. Now, it may be a case that you might have swung, all right. You may brandish somebody with a knife, but you don't hit him. It's an attempt to murder. You might have hit him and you missed. But had it struck him, he would have died. It's an attempt to murder.
Yes.
So the doctor report says what? What does it say?
Half-inch.
Para 5.
Para 5.
Cut by a sharp weapon.
No, but I give him a suggestion, para 2 or 5 cross or so,
This is these suggestions. This suggestion is a general suggestion.
Yes.
You're saying that if a person falls from the building, he might break his leg. Yes, break his leg. But how do you connect this suggestion with the medical evidence? Doctor opined that yes, you may also have a cut injury out of a fall. Where is the evidence that he fell down?
My contention is in here that there might be a possibility.
This possibility there has to be some basis for looking at that view also. That there is a possibility also, because he also says that I fell down. The accused says that while I was running, I fell down. So then you can connect that. Look here, there is an evidence that he fell down, and the doctor also says that even if this kind of injury which was found on the body of the accused may also be due to a person falling down. There is a connect. But from where are you saying that he fell down? From where are you saying that the victim fell down, PW4?
And moreover, he stated he was hit by a spade, and he stated that, moreover, he stated also that, when he looked back, he saw accused carrying a dao,
Right.
That
He never stated that he was hit with a dao.
he said a spade,
Spade.
He never saw, he stated, I saw a spade, person carry a spade,
Maybe. Spade means what? What do we mean by spade?
Okay.
There's a difference, that's the problem, is that we are conducting the proceedings in English.
Even FIR also state mokyo.
Mokyo is a hoe, not a spade. Mokyo, there's a difference between mokyo, hoe, spade. Spade is a small spade. Evidence not been recorded in appropriate words. It may carry wrong meaning just because the appropriate word was not used for the weapon or the instrument used by the accused. We will not discard it. Perhaps they have not used the word spade. What do you mean? What do you mean by spade? What is spade? Give the dictionary. See, check in your Google. What is spade?
Tools used for digging.
Tool
used for digging. Tools used for digging.
Digging. Yes. What is hoe?
Used for chopping wood.
For chopping wood.
Hoe. HOE.
Both materials have a handle.
Yes. That's all? Both the accused are here?
Both accused are here.
That's all?
And the question who had hit him is not explained by the prosecution.
Very good. Under such circumstances, Section 34 comes into play. Both will be liable. Section 34 says what?
Common intention.
The act has to be committed. Well, madam, but why evidence are recorded like this? In a case of attempt to murder, one paragraph is the evidence of a victim. What is the punishment for 323?
It's 3 years.
1 year for 323. 1 year or fine?
No, not 1 year.
It's 323. Punishment for voluntary causing hurt.
3 maximum is 1 year.
324.
Oh, 324. The maximum is 3 years, or with fine or with both. Moreover, in this case, the alleged weapon was never seized.
Not required. Why did you hit him? Why did you hit him? What is the explanation?
My explanation, I never hit him. My explanation on 313 was while the accused was in the paddy field planting crops, this victim came and catching fish and stepped on the.
That goes against you. Making false statement under section 313 provides an additional link. It may not be an evidence, but it provides an additional link of you trying to evade or mislead.
If you read their whole statement, I just briefed statement. He stated while they was planning, or they were in paddy field planting crops, this victim came and started stepping on the crops while catching fish, and then they chase him away, not to destroy the crops, not to step on the crops. Then he ran away while chasing him. They stated he fell down, although they stated they did saw whether he injured himself or not, but they chased him away. That's their answer. Yeah.
Now, madam, just satisfy me one thing. That what happens to a trial when the accused was not given the right to be heard before consideration of charge?
So that it's only if the accused pray for hearing before charge, then a charge will be framed only after being heard. But if there's no prayer made by the defense on that part, so the case will be proceeded to framing of charge.
No, the accused has the right to be heard before framing charge, but if he does not exercise his right, then charge can be framed.
Yes.
Does it vitiate the trial? Come to section 460.
Irregularities which do not vitiate a trial. If any magistrate not empowered by law to do any of the following things, namely, to issue a search warrant under section 94, to order under section 155 the police to investigate an offence, to hold an inquest under section 176, to issue process under section 187 for the apprehension of a person within his local jurisdiction who had committed an offence outside the limit of such jurisdiction, to take cognizance of an offence under clause A or clause B and subsection 1 of section 119, to make over a case under section 2 or subsection 2 of section 192, to tender a pardon under section
So
306.
please read clause E.
To take cognizance of an offence under clause A or clause B.
Please read section 190.
cognizance of offences by magistrate. Subject to the provision of this chapter, any magistrate of the first class and any magistrate of the second class, especially empowered in this behalf, the subsection 2, may take cognizance of any offence. Upon receiving a complaint of facts which constitute such offence, upon the police report of such facts, upon the information received from any person other than the police officer, or upon his own knowledge that such offence has been committed. The Chief Judicial Magistrate may empower any magistrate of the second class to take cognizance under subsection 1. Such offence are within his competence to inquire into or try.
Come to section 461, clause K, sub clause K.
Purchase and sell property under section 83.
No. K.
Take cognizance of an offence under clause C of subsection 1 of section 190.
Yes. Yes. That's all. That's all. Take it. The genesis of the instant criminal proceedings is in the FIR dated 22/5/2010, filed by Srimati D. Gratia Smo before the officer in charge, Juai police station. Full stop. The informant has alleged in the FIR that a driver, Mio Susni, suffered physical injury in the hands of the accused Plan Dakhar and Sihon Dakhar. Full stop. The accused had used O to cause the injury, while the driver was engaged in fishing at a place called Tumthornian, Mimidudu. It is also alleged that the two persons named in the FIR had given a chase to the driver with a dao. The FIR was received by the Joai police station by GD number 568 dated 22/5/2010 at around 6 p.m. and it was registered as Joai PS case number 83/510 under section 307/34 IPC, and the case was entrusted to ASI MN Sangma for investigation. During the course of investigation, the victim was medically examined at Civil Hospital Joai. Statement of the witnesses was recorded. The IO could not make any seizure of weapon alleged to have been used. The investigation concluded in a charge sheet number 81/10 dated 3/9/2010 under section 324/34 IPC against the two accused persons. In perusal of the charge sheet, continue. On perusal of the charge sheet, it emerges that the prosecution filed the charge sheet relying on 3 witnesses to establish the charge. He was CGM that time. 2017 he was CGM. This Kirbor's signature. He was CGM. No, GMFC.
UFC. You got promotion here, man. UFC. If I'm not mistaken, it was GMFC.
GMFC.
Promoted here in July.
When was the charge sheet filed?
3/9/2010.
What did you write last?
On perusal of the charge sheet, it emerges that the prosecution filed the charge sheet relying on 3 witnesses to establish the charge.
Charge. First off, the charge sheet was laid before the learned ADM July on 9/9/2010. Thereafter, the order sheet reveals that stereotype orders were passed for the appearance of the accused. Without any indication of any steps being taken to secure the presence of the accused. Stop. After the separation of the judiciary from the executive, the case was transferred to this court on 28/2013. Stop. The case was remitted to learned CGM for disposal. The case was referred to learned CGM C. Dakhar for disposal. By the order dated 28/2013. Here, comma, again, the matter was pending before the learned CGM for appearance of the accused and copies and supply of copies. It is very interesting to take note of order dated 21/5/2015 passed by the committal court. That the learned committal court. It is very interesting to take note of the order dated 21/5/2015 passed by the committal court, comma, whereby the committal court had given way to the argument of the defense counsel that the parties are tribal and the case should be tried by the district council. District Council Court. Full stop. The order dated 21/5/2015 reveals that the case was transferred to District Council Court. Full stop. The case was pending before the District Council Court. Comma. Surprisingly, the District Council Court, by order dated 7/9/2015, has recorded that charge sheet in the instant case has been filed under section 307/34 and section 324/34. Why the district council, if the punishment is life imprisonment, district council does not have jurisdiction?
It does not have the session power.
34. Charge sheet has been filed under section 37/34 IPC and section 24 IPC. The district council court does not have the jurisdiction to try cases which is exclusively triable by the session court. As such, the case was sent back to learned Chief Judicial Magistrate Joy. Full stop. The order of the learned District Council Court dated 7/9/2015 was never challenged. However, the order was passed on misreading the charge sheet. It is reiterated that the charge sheet in the instant case has been filed for an offence under section 324/34 IPC. After the case was remitted back, it was fixed once again for the appearance of the accused. Upon number of dates. However, there is nothing on record to show that any steps was taken to secure the presence of the accused. Full stop. It appears from the order dated 27/7/2017 that both the accused persons entered appearance along with their counsel. Copies were supplied. The learned full stop committal court once again recorded that the charge sheet has been filed under section 307/34 IPC and committed the case to this court for the purpose of trial. This court has failed to comprehend as to why none of the committal court had perused the charge sheet inasmuch as the charge sheet distinctly reveals that it has been filed for an offence under section 324 stroke 34 IPC. To excabrate the matter, exacerbate the matter, learned defense counsel conceded to the charge by the order dated 27/6/2018. Full stop. Charge was framed against the accused person under section 307 stroke 34 on 26/10/2018. The accused persons pleaded not guilty and stood for trial. The prosecution took 7 years to produce 4 witnesses The details of the witnesses are in Appendix 1 and exhibited are 4 documents. The details of the exhibits are in Exhibit 2. Full stop. The accused persons were examined under Section 313 after the conclusion of the prosecution evidence, and they were given an opportunity to bring defense witnesses. Full stop. Both the accused persons declined to bring any witnesses. The matter proceeded for final argument. Full stop. This court has recorded this court has recorded no, this court has spelled out above how the case has traveled how records were overlooked, which has not only resulted in delay in trial, but also depicts the cavalry manner in which the material and records are examined. Which is a very sorry state of an affair. Which is a very sorry state of affair. Full stop. Coming to the merit of the case, and this court finds the argument of the prosecution needs to be briefly encapsulated. Hold on. The prosecution has submitted that the informant PW1 has established that she filed an FIR, Exhibit 1, on the day of the incident. PW1, along with her two friends, Hamsalit Rambai, Srimati Hamsalit Rambai, and Srimati Elmi Suting, along with the driver Mio Susni, went to River Mintadu for washing clothes. After dropping the informant, after dropping PW1 and her friends, the driver returned back. PW1 saw the driver Mio Susni running towards her while she was washing her clothes. Bleeding from his waist. The driver disclosed that he was assaulted by some person at Klitirshi. The driver was taken to Mission hospital for treatment. The prosecutor submits that the evidence of PW1 establishes that she saw the victim with an injury on his waist. On being assaulted by some person. PW2 who was fishing at Mimituru River saw the driver Mio Susni crying and shouting for help. He also saw the driver with injury on his body, with injury with injury on his back of the body. PW2 was informed by one of the cultivators that the assailant were the accused person. PW2 along with Friday Hing and PW1 took the driver to the hospital for treatment, and thereafter FIR was lodged. PW3 is the investigating officer. The evidence of the investigating officer reveals that the accused could not be apprehended during investigation. However, she concluded the investigation could not be apprehended during investigation. The accused persons had secured pre-arrest bail DIO had filed the charge sheet under section 307/34 IPC against the two accused persons. PW4 is the most vital witness of the prosecution case, as he is the victim. PW4 stated in his evidence that the incident took place on 22/5 2010 at Wa Mintidu River. Full stop. PW4 was fishing to the PW4 was fishing in the river. The two accused persons came from behind and struck him with a spade on the left side of his back. PW4, after being struck by the accused, by the accused persons, ran away. However, the accused persons followed PW4. PW4 saw the accused plunge Dakar carrying a dao in his hand. PW4 was informed by PW2 that the name of the two persons who had inflicted injury are Plan Dakar and Shihon Dakar. Full stop. PW4 had also identified the accused during trial. Identified both the accused during trial. PW5 is the doctor who examined PW4, who had medically examined PW4. Stated in his evidence that he found half-cut injury in the lower back of PW4. The injury was 6 hours old and it was simple in nature. PW4 prepared a report. PW5 prepared a medical report which has been exhibited as Exhibit 4. The prosecution, after laying out the prosecution evidence, summed up by submitting that the witness PW4 has established that he was hit with a spade on his back by the accused person. causing injury. The injury has been established by PW5. PW2 establishes that the accused persons were the person who had caused injury to PW4. PW3, PW1, the evidence of PW1 finds corroboration with the evidence of PW2, 4, and 5. The prosecution submits that both the accused persons had inflicted injury on PW4 using a weapon with the intention to cause death of PW4. Stop. Had not the PW4 escaped, both the accused person would have killed PW4. Prosecution prays for conviction of the accused under section 307 and section 24 of IPC. 324. Full stop. The defense has argued that the evidence of PW1 simply establishes that PW4 suffered injury on his waist inflicted by some person However, PW1 had categorically stated in a testimony that she is not a witness to she's not a witness to the crime. Full stop. Learned Defense Counsel has also contended that PW2 Learned Defense Counsel contended that the evidence of PW2 also simply establishes that he saw PW4 with an injury full stop. However, he was informed about the involvement of the accused by one cultivator, and the said cultivator was never examined as a witness. Comma, rendering the evidence of the PW2 as a hearsay evidence. The evidence of PW3, the investigating officer, reveals that though the FIR was registered under section 307 IPC, however, the charge sheet was filed under section 324/34 IPC. In as much as offense under section 307 IPC was not attracted. Stop. PW4, the victim, stated in his evidence that he was assaulted on his back with a spade. And he saw the accused plant the car carrying a dao in his hand. And giving him a chase. The defense has stressed on the evidence of PW4 by submitting that the name of the accused persons was informed to PW4 by PW2. The accused persons were not known to PW4. PW4 has stated that who had hit him among the between the two persons, he did not know. The defense submits that it is the guesswork of the PW4 that the two accused persons were the person who had hit him and given him a chase with a dao. Finally, the defense submitted that the medical report of the accused, Exhibit 4, and the evidence of PW5 reveals that PW4 had suffered simple injury and it does not attract section 307 or for that matter section 324 IPC. Prosecution, the defense submits concluded that prosecution case stands on the evidence of PW4. The evidence of the PW4 does not conclusively establishes that it was the accused persons who had inflicted injury on PW4 or they had made an attempt to cause death of PW4. Full stop. Next paragraph. For the purpose of determining the charge, point for determination is curled out. Next paragraph. Whether the accused Plan Dakar and Shihon Dakar caused injury on the body of PW4 by using a spade on 22/5/2010 at Wamyuntudu River while PW4 was fishing. Stop. Next, whether the accused both the name had given a chase to PW4 with accused Plan Dakar carrying a dhow with an intention to cause his death. Stop. Next paragraph. How long they have remained in jail?
You never arrested.
How old are they?
Understand me? Plan? Huh? 49 for plan. Yeah. So what? 42 for Sihan.
Huh?
42 for Sihan. Me so far me.
He's 42.
Me have.
Does he know his age? He doesn't look like 42.
Maybe don't know that age.
Huh?
But he is the eldest plan. He's 14. Me so Monday now. Me so we. Kenapa? Huh? Coba 49 and 42.
You want to go for lunch? Huh?
Yes.
Come back. You'll come back, we'll finish. that the injured witness is an interested witness or has been tutored or has deposed against the accused out of personal vendetta. This evidence cannot be brushed aside casually. Stop. PW4 is the injured witness. The testimony of the PW4 reveals that is the victim in the instant case. The incident took place on 22/5/2010 at Wa Minturu River. Stop. Further, the testimony of PW4 also establishes that he received injury on his abdomen. His testimony corroborates with the evidence of PW1 who saw the victim with an injury, who saw the victim bleeding from his waist, PW2 also saw the victim with an injury on his body. The nature of injury has been explained by PW5 doctor. Stop. The doctor, in his evidence and medical report, Exhibit 4, has established that the injury was fresh and it was half-inch cut injury on the lower back, left side, caused by a sharp weapon. The nature of the injury was simple in nature. The injury was simple in nature. The prosecution is established that PW4 received injury on 22/5/2010 at Wamintu River. And the injury was simple in nature. The next question which falls for consideration as to who had caused the injury. PW4 has stated in his evidence that two male persons Shihon Dakhar and Plan Dakhar came from behind and inflicted injury with a spade. PW2 came to his rescue. The two persons fled away. And the assailant, they say not two persons, came to his rescue. Came to his rescue, comma. The assailant, on seeing PW2, fled away. PW4 has stated in his cross-examination that when he was hit from behind, he could not see the assailant. However, when he turned back, he noticed that the accused persons were the assailant, he did not know who between the two had caused injury to him. Stop. The defense has argued that the accused has made a guess that the accused persons were the assailant. This court finds that the argument of the defense counsel does not convince this court. Stop. the witness PW4, PW2 has testified that he was informed by one of the cultivator that the two accused persons were the assailant. No doubt, the cultivator, no doubt, non-examination of the cultivator renders the evidence of PW2 as a hearsay evidence. However, hearsay evidence cannot be totally discarded. It can be looked into if it can be looked into for corroboration. It can be looked into for corroboration of substantive evidence. Doc identification is something which should not be resorted to should not be resorted to in a routine manner. Stop. In the case in hand, the victim PW4 has stated in his evidence that the victim PW4 during the course of trial has testified that the two accused persons, Plan Dakhar and Shihon Dakhar, who were present in the dock, was the person who had inflicted injury to PW4. Stop. From the defense argument, it can be gathered that the contention of the defense is that PW4 could not identify the assailant. The evidence and record does not substantiate the contention of the defense. As PW2 had named the accused, persons on being informed by the cultivator. It is not a case where PW4 had given the description or identity of the PW2 had given the description and identity of the accused persons to PW4. Stop. PW4 being a victim saw the assailant. However, he did not know their name. PW2 had simply revealed the name of the assailant to PW4. Stop. PW4 had identified the assailant in the dock. Stop. The prosecution has established that the accused planned Sion Dakhar and Plan Dakhar had inflicted a bodily injury to PW4, and the injury was simple in nature. Stop. The weapon used for causing injury was never seized. The identification of the weapon can only be ascertained through the injury. The weapon used was a sharp weapon as per the medical report. Exhibit 4. Stop. The act of the accused, the act of both the accused of causing injury. Nay, there is evidence to show. Nay, the evidence of PW4 establishes that both the accused persons were present. An injury was inflicted on the back of the PW4. There is also an evidence that the accused person had given a chase. Section 34 of the IPC kicks in. Which envisages act done by several persons in furtherance of common intention. Which envisages when a criminal act is done by several persons in furtherance of common intention of all, each of such person is liable for the act. In the same manner, as if it were done by him alone. Stop. Here the criminal act is causing injury. Both the accused persons were present. They had given a chase to the accused with an intention to harm him. Who had harmed him? Need not to be established. as the act of the accused. The act of the accused persons was in furtherance of common intention to harm the accused. As such, both the accused shall be jointly liable for the criminal act. Stop. Now, this court has to examine if the act of the accused, act of the accused persons falls under section 324. Stop. Section 324 provides voluntarily causing hurt by dangerous weapon or means. The opening word of section 324 is very important. The word voluntary is defined as voluntary under IPC. Has been defined under section 39 of IPC, which reads as a person is said to cause an effect, inverted comma, voluntarily when he causes it whereby he intended to cause it, or by means which at the time of employing those means, comma, he knew or had reasons to believe to be likely to cause it. The accused persons had caused injury to the PW5 when he was fishing, and the assault was from behind. Which clearly indicates that the accused persons intended to cause physical harm to the physical harm to PW4. As such, the act of the accused was voluntary. No recovery was made of any dangerous weapon. But the evidence of the doctor, PW5, that the injury was caused by a sharp weapon remains unimpeached and confirmed in cross-examination. Which only establishes that injury suffered by PW4 was with a sharp weapon and it can be safely assumed that it can be safely assumed the weapon was dangerous weapon or the means adopted by the accused was dangerous weapon, or the means adopted by the accused to cause injury to PW4 was an instrument which had a potential of causing death. This court finds the prosecution has established that both the accused persons has inflicted voluntarily has caused voluntarily injury, hurt, has caused voluntary hurt to PW4 using a dangerous weapon and are guilty for an offence under section 324 IPC. Next.
Whether the accused Blandakar and Sihambikar had given a chase to PW4 with the accused Blandakar carrying a dao with an intention to cause his death.
Stop. Next one. Any act within intention or knowledge and under given circumstances that, comma, if by that act cause death, he would be guilty of murder. He shall be punished with imprisonment guilty of murder, only murder. No, not he shall be punished. Is the definition of an attempt to murder under section 307 IPC. First of all, that on evaluating the evidence, this court finds the prosecution has established that the accused persons had caused injury to PW4 and the injury was simple in nature. Stop. The testimony of the prosecution witness Nowhere establishes that the injury was inflicted by the accused with the intention to cause death of P4. This becomes more apparent from the nature of injury. The doctor's evidence reveals that the injury was simple in nature and not life-threatening. The accused persons were very close to P4 if they had the intention to cause a fatal blow, to cause a fatal injury. They would have struck P4 on the vital part of his body and caused his death. Prosecution has also failed to establish that the accused persons had inflicted injury with an intention to cause death. Had they succeeded, the accused would have died. Comma? No, not died. Died. It was no. The intervention of PW2 restrained the accused person to carry out the intended act. The act of the accused in causing injury to PW4 cannot be considered to be life-threatening falling within the four corners of attempt to murder. The prosecution evidence does not support the charge of attempt to murder. Both the accused persons are acquitted of the charge under section 307 IPC. Full stop. Conclusion that for the reasons discussed above, The accused Plan Dakhar and Sihon, no? Are acquitted of the charge under section 307 IPC. Full stop. However, they are found guilty for an offence under section 324 IPC. However, they are found guilty for an offence of voluntarily causing hurt with a dangerous weapon and convicted under section 325 IPC. Both the accused persons who are present before this court are taken into custody. Bail bond of both the accused persons stands revoked. The accused has been informed of his right to prefer an appeal. Fixed for hearing on sentence. Aboli. Sentence. Sentence. You want to hear now?
Can do it after.
No.
Next week, sir.
Huh?
Next week.
Next week. No problem. Up to you parties. You want now sentence?
Can do it now, sir.
Huh?
Can do it now, sir.
Boli.
It's okay if they want to.
Boli.
Go to the mitigating factor of the case.
Now 6 o'clock. Inform them.
Next day is fine.
Inform them they have been found guilty.
Ama, din wada rai ni ko the cham iwa the cham ko wa pi the dat yo ni me yusus ni ai tu ga ar trek penausan ada ha the cham gi wa dat yo the tiar wa nep ra ra kan mi pi untuk then leong pi I'll just ask if you have any the leong pi ar bu dong wa ti ong ni ko la lor gani ra kan mi pi man gani kan don penhap ti mem mut to kan yap tang wa kan so yo ka ade cái test so ra kan mi aha the cham ga sa wa the cham ko to le seeking for forgiveness, apology.
Thereby occupation what?
EP credit penabi
Which year case this one?
penabi
Huh?
It's 2010.
Oh, 10. 10, 10, 20.
26
Huh?
16 16 sorry
क्या मांगते हो आप सेंटेंस क्या चाहिए आप
2 years.
हाँ
For 2 years.
yes
if you read through the section it's I'll just go to punishment
thereby occupation what
are the farmer
married
khan empty mana mega number khan son huh bro plan has 5 children and
any criminal case there
no it's not the case
not 2 years
no, it's stated or fine I'll just the mitigating factors that it's a heat of moment the person who's trespassing and moreover we have since after
they are rich or they are poor honest answer
they are poor the alleged offense also happened by the farming by the field
you want how many years sentence
For 2 years.
2 years.
No, the punishment is
going
maximum
for-
3 years.
Okay.
Maximum 3
Maximum
years,
is 3
but
years.
there's no minimum prescribed
No.
because
Yeah.
it may extend
Why
to
should
3
you go
years.
more than half? Too much. How many months they sentence? How many? According to them, how long they want to be in jail?
Ama in the court. They talk in the case into the permission of the news. In the young team, kamu ni apa gitu? Dia yang kepala set pe, kamu kepala set pe. Itu le pe.
Tell him the maximum is 3 years.
Ke gani ke kendau nopo ipi dengan ia kau pikir ado desnam, Kau head tu sah. Pilihan muslim, ado kena, muslim senyai happy set pe. Itu le pe.
What he says?
Seek apology.
You forgive him? Yes. You forgive him? Huh? All right, do one thing. If you are prepared, we'll hear it. You have to pass away the reason order. Since we have convicted, we have taken the pain of passing the judgment. So after convicting somebody, we have to be very serious on the sentence. Now these are, one thing is that this crime is not a crime of that nature which affects the public at large.
Yes.
Right? If it's a rape case, it's a murder case, or it's a case where we cannot. But this is more between two persons. Injury has been inflicted to one person. Okay. So, yes, prosecution, tell me what you do. Just don't ask. Just because you are sitting as a prosecution, don't make things complicated. You have to be very fair also. They don't have any criminal case?
No.
Huh?
We don't have.
This is the only criminal case.
This is.
But when the matter was sent to district council, why it came back here?
That I don't know.
Why did they hit him? Why? The explanation in 313?
Explanation of 313 steps.
No, we will take into consideration, we'll show some leniency.
Even to
Sometimes truths are very strong.
yes, they were a farmers, by
But
occupation.
we are not recording 313.
Yes.
That's why I'm saying that the 313 is not evidence we use it. Even if you say something on 313, we don't use it. But it may help. Had he said that, yes, we hit him because we have got a farm, we have already said don't come for fishing here. You're spoiling our crops. Then he came and when people come for fishing, they spoil our crops. So we have to chase them out. No? So all that we did is we chase. As a farmer, we have to chase them carrying stick and carrying with a dao PCC. As I said long back, if I just look at that a person carrying dao and chasing somebody, isolatedly, if you look at in isolation, if you look at it, looks so dangerous. But farmers here, when they go to the farm, it's part and parcel of your dress. It's a tool you have to carry. You chew kwai, you carry small knife. To clean the grass and everything, you'll have one dao with you. So any dog comes, animal comes, you protect yourself, you cut the branches. So that is not for the purpose of killing somebody. They are not some criminals carrying weapons and moving around in the jungle. These are the tools they always carry with them. They might need it any time. These are the equipments which is required for them as a farmer. They keep with them. Like people here, they chew betel nuts. They always carry that knife, not for committing murder. Not to be understood in that sense that they were chasing somebody with a dao. So they have their move. If they have to give a chase to somebody, they'll take out the knife and everything and keep it in one hand. So that we understand. That's why we are not on that. I don't want to go deep into this section 307. Yes. Do you want time till tomorrow, or you want?
Tomorrow we have arguments.
What argument?
One rape case and then hearing on sentence one.
Yeah, I want to keep people busy.
It will take time.
Yeah.
My only prayer is that
Huh?
maybe fine goes to them.
Fine, it's very less.
Huh?
Fine, yes.
And I have one half
Because
5
the
children,
victim here
the other
suffered
half 6.
injury.
Huh?
Because here the victim suffered injury, and
Yeah,
the injury also
injury
was
was
caused by a
although
Do you
they
have a
weapon.
crossed-
farm?
No, no.
No, do you have a farm?
No, I understand, sir. No.
Somebody enters in your field, what you do? You chase him, isn't it?
Although injury was inflicted, however, if you look into injury, it's not
Why
that
did they hit?
nature.
Yes, we have to know from them.
That's why the
At
injury
least
is
I'll come.
simple.
If,
That's
if,
why
we,
I'm
if
praying.
you don't hear the
The-
matter
the
today,
fact
if I
is-
come tomorrow, then I'll come well prepared.
The fact is
They-
that they
I want to hear from them. Why did they hit him? Yeah. Honest answer. This will help them.
He went and stepped on the agriculture, the crops. It hate. They destroy the crops. So that's the.
What to do?
That's the honest answer given today. The reality is that he came, destroyed the crops. They told him not to do so, but he didn't listen.
What is it?
Sir, he confront him first, and then and the victim tried to assault this. He tried to assault the Sehan, and he. Sehan hit him. They were fighting with Sehan, and then he hit him.
Why you did not bring all these things under 313?
Yes, sir, no?
Why you did not bring under 313? Had you brought all these things, I would have acquitted you.
That's what they did.
No, 313, you stopped the point that I never hit. Why you did not bring all these things under 313? These facts pitted against the evidence of prosecution. Prosecution evidence false. Protecting your land is not an offense. You should have brought these two persons as a TWs. Had you brought all these things in your 313, so I would have been in a better position. I would have referred to a 313. They hit, yes, they hit. But the circumstances under which they hit, one, protecting the land. Second, they tried to warn them. And when they warned this, the PW4, because they don't have any past history of enmity, why will somebody hit somebody? So please try to understand. Certain facts are there. But yes, madam, I'm not inclined to be harsh on them. There are many more. There are many more hardcore criminals. You put up a strong arguments for very stringent sentence, and we will not show our law to these people. Yes, yes. You file an affidavit, proper affidavit. Tomorrow we'll take it up. Tomorrow we have two sentences.
Yes, one sentence and one argument.
What
So
argument?
two sentences with this one.
Yes, yes, yes. Yes, yes. Come prepared. Don't take it as somebody's life.
Next week.
Next week. No. Why should we keep them in jail for long?
Tomorrow.
Huh? Sorry?
Tomorrow.
Tomorrow. Tomorrow, madam. Come. Be fair.
Okay.
You place all the facts before me. The families, the everything. We will. We understand. We don't want to be harsh with them. Okay. What will be the judgment dictated in open court? Accused acquitted of the charge under section 307. However, found guilty under section 324, both the accused persons are taken in custody. And sent to district jail. They shall be produced before this court tomorrow for hearing on the quantum of sentence. Tomorrow? Okay. They want anything to say both? कुछ बोलना है तो बोलिए.
You have stated that
Huh?
seek forgiveness, that's all.
Tomorrow we'll hear. Tell them. Tomorrow we'll decide how long we'll keep in jail.
Itu berarti kamu step uraikan set itu, itu pol. Step urai dan sah. Mentu ada lagi, jadi tema step sah.
The brother, दूसरा वाला?
मेरा नाम ग्राम में यहाँ में. Forgiveness and also having children, that is to the honor of the family.
Okay. Tomorrow we'll see. But today you have to go to jail. What is this? What is this?
You wanted to go home and you'll come back tomorrow.
Where they stay? Huh? We can't be so lenient. Tomorrow. Yes.
So I
Anything?
have one case for acceptance.
Give. Which case? You see, this call this Langbang. Lambang. See, you file, you go back. You can, if you want to talk to him, you can talk to him.
Yes.
But it will be appropriate that you file one affidavit.
Okay.
All right. Bringing all the facts, the circumstances under which the crime was committed, everything. Na? You bring all those. Give me file in the morning. Then we will be in a better position to appreciate that how, because she filed one affidavit for one case, na?
Yes, the Marak.
Marak case. So we could take a proper decision. Okay. You can prepare now only, and then you can file tomorrow. Okay. Yes. Who is she?
She's the mother of the case.
What is the bail order?
Order dated 19/4/20.
Yeah. It is 16. Today?
Today 20.
She's the mother.
Yes.
Tell her that this man will come
Yes, I
Your
have
quote on
explained
the-
her, yes.
Thank you.
Okay.